Your RRN TV on-demand video will begin shortly. Meanwhile, be sure to register for RRN TV alerts by clicking on the link below. I'm here with Sanford Elsass, Chairman of the National Risk Retention Association. Mr. Elsass, welcome to the program.
Marisa, I'm delighted to be here.
Legislation is a big issue. What is the biggest legislative concern facing risk retention groups and captives these days?
Obamacare is a big deal for those of us who have medical malpractice risk retention groups and/or captives. You're going to have 30 million people who've not had a lot of experience in receiving care, and if that experience doesn't work out very well, there are going to be a lot of lawsuits, and those people are on the poverty line, a lot of them. And so you got a combination of no money, and all of a sudden they get care, and if they don't like the care, they sue for malpractice when they learn that game. That's a very big issue.
Are there any other major legislative issues?
Well, there's a lot of people who run standard lines companies who've been fighting with Congress to try to level the playing field on the tax issue, where the offshore domiciles have a competitive advantage due to the differential of the tax. Now that there are roughly more than half the states are captive domiciles, and they're looking to garner business, and so there's I think a built-in regulatory or a competitive environment where the tax issues can't get out of control because people would re-domicile themselves either to another state or offshore. So that business has become very competitive. I think the bigger concern for us as RRGs are states that are basically violating the law by ignoring the Liability Risk Retention Act. That's our biggest problem.
Can you give us an example of where this is happening?
A particular problem that we have is California, and the California people say to an RRG, you cannot do business here when the law says that we can, while Jerry Brown claims that they've got financial problems. When it comes to lawyers, they've got an unlimited supply of lawyers who can put pressure on a risk retention group. The risk retention group will have to go to court or to fight and/or hire its own lawyers to fight in order to just do business the way they're allowed to do business by the NRRA, the Act. And a lot of the risk retention groups don't have the balance sheet strength to fight that fight. So one of the things that National Risk Retention Association does is to help those people, and we jump into the fray and help out with amicus briefs and/or defense, as the case may be. So that's why we need a change in the legislation in order for the federal government to create an arbitration clause to where those states that have tremendous size and strength and bruteness can be calmed down and let the risk retention group operate under the law as it should be allowed to do.
Sandy, thanks again for being on our program.
Thank you very much.